One that I have found gets a visceral reaction from the jury is, I'd like you to imagine that you're serving on a jury and it's a murder case. And the only evidence whatsoever that a murder occurred or that the defendant did it is some evidence that was found in his car. They found the murder weapon and they found his journal where he described in grisly detail what he'd done to the victim. But as the evidence progresses, you learn that, well, and you've got to set up what 3823 says, which is if an officer violates the Constitution or any state or federal law in order to obtain evidence, the jury is not allowed to consider that evidence. And so in this case, the only evidence connecting this defendant to a murder is what was found in his car. But when you get to the end of the case, you either think that it was an unlawful search or you're just not sure that it was a lawful search. The judge is going to tell you that if you're at that point and you're not convinced beyond a reasonable doubt that it was a lawful search, you're not allowed to consider that evidence. And in the example I'm giving you, if you don't consider that evidence, you have to find this guy not guilty because there is no other evidence that he's guilty. And this is one where I go juror by juror. Juror number one, could you ignore evidence that you've already heard and find that defendant not guilty, even if you're 100% sure that he is guilty? Without fail, the first 3 or 4 jurors are going to tell me, no, I don't think I can do that. And then you'll get one guy that says, yeah, I mean, I wouldn't like it, but yeah, I would follow the law. On several occasions, I've told that person, look, I've never been put in that position. I don't know that I could do it on a case that serious. When they hear you say that sometimes we're going to ask you to do things that are not easy to do, I have found that it gets through and it gets people more willing to say either, yeah, I could hold my nose and do it, or no, I can't do it. Now, the beautiful thing about that particular setup is it creates visceral reactions. It puts the jury in a position of having to make a really, really unpleasant decision. And anybody that says that they can't do it is going home. Anybody that says that they can do it is probably going to be a more favorable juror to your case than your average juror, even without the 3823 issue. If there is a colorable claim that you might have a 3823 issue arise in your case, you are entitled to, and you're a fool if you don't get a 3823 qualified jury. 3823 qualified juries are better juries for defendants because they've shown you that they're willing to engage in the academic exercise that a criminal trial really comes down to. I can't yet think of a criminal trial that has gone all the way to a jury trial where in my normal day-to-day interaction, if I was presented this problem with this evidence, what do I think happened here? Oh, I think you probably did it. Anything shy of that, in those cases, don't go to trial, right? You want a jury who's willing to engage in the intellectual exercise. A 3823 qualified jury is one of the best ways that I've seen to test whether you're actually going to get what you're hoping for. And like I said, anybody that says, no, I can't do that, they're going to be gone. Okay. Some of us have practiced in courts where the judges are, and no judge wants to bust a panel. A busted panel means you've wasted a morning, and at best we'll get another panel back this afternoon to spend another 2 or 3 hours doing it. Some judges are more hesitant than others to bust panels, and some are loath to grant a strike for cause. They'll do everything they can to rehabilitate them. There is a provision in the code, and I forgot to get it, I meant to put it on here, but there's a provision in the code that says that a juror cannot be rehabilitated if he has testified on voir dire that he has a bias or prejudice against a particular rule that will prevent him from following that law if he were placed in that position. Once he says, yeah, that's me, no amount of rehabilitation will fix him. The judge may still try, and we're going to get here in a minute to what you need to do in that situation, but that guy is gone. One of the ways that I have found to do that, if you feel like you're dealing with somebody who's kind of on the fence, but you could tip them, remember, and I'm giving you guys this as background, you figure out the way to put this to that panelist, but at the point that you're dealing with them in voir dire, they are under an oath to tell the truth, the whole truth, and nothing but the truth, but that's it. They are not yet under an oath to want to follow the law or to follow the law. But the very first thing they're going to do before the defendant is arraigned is take an oath to follow the law. Our system was created at a time when it was believed that breaking an oath was an unforgivable sin and would damn you to eternal hellfire. Our system was built around that. Number one, oaths are very important in our system for that reason. And number two, we don't want to put somebody in a position of taking an oath knowing that they're not going to be able to follow that oath. And so when I've got a juror that I think is kind of on the fence, the judge can rehabilitate them, but I want them gone, I'll tell them. Right now, your only obligation is to be truthful. The clerk or the judge or whoever made you take an oath that you would honestly answer the questions. You're not obligated to follow the law at this point. However, if you're placed on this jury, they are going to make you take an oath to follow the law as the law is written, whether you agree with it or not. And we don't ever want to put somebody in the position of having to decide between their oath and their conscience. So, it sounds to me like you have a problem with this law that you would be asked to follow. Would it be fair to say that you disagree with this law? And usually, innocuously, when you present it that innocuously, they'll say, yeah, I disagree with that law. Okay, well, based on the things that you've said, it sounds to me like you would have trouble following that law if you were put in a position of having to decide a case based on what the law says you need to do with this particular issue. Would it be fair to say that you would have trouble following that law? Yes. All right. Well, I think that law may become an issue in this case, and neither the judge or I want to put you in a position of having to choose between your oath and your conscience. And so, do you think it would be fair to say that your problem with this law is sufficient that it might interfere with you following your oath if you were asked to decide the case on that issue? Yeah, I think it might. All right. Well, then, I think there may be other cases where you would be an excellent juror, but this may not be the one for you. Do you think that would be fair to say? And usually by that point, if that person really does feel this way, they'll say, yeah, if this case is going to come down to that issue, I don't think I should be on this case. All right. Well, then, I'd like to ask your permission to have the judge excuse you from this case, and the next time you're up, hopefully it'll be on a different sort of case. Then you make your motion to strike, and the judge can do whatever he wants. But number one, you've gotten that guy to say everything he needs to say to make him beyond rehabilitation. Number two, you've done it in a respectful way so that nobody else on the jury panel feels like you were bullying him into kicking him off. And number three, this voter has just told an elected judge that, hey, for the reasons he just talked about, I don't think I'm a good candidate here. I've never seen a judge try to rehabilitate one of those. Well, no, I take that back. There's one court. This is not appropriate in every case. But if you know you're in a court where that judge is going to bend over backwards to keep from excusing anyone for cause, taking the extra couple minutes to walk the worst, you've also got to use this selectively. If you think you've got 10 strikes for cause, you probably don't have time in the limited time they give us to go through that whole spiel with each of those 10. You've got to find the ones that are worst for you that you've really just got to get rid of. But once that juror says, yeah, you can ask the judge to let me off, the judge is going to be a lot more hesitant to try to do anything other than let this voter off, because you've given him a real good case for why that juror doesn't want to be on this jury. So, what do you do when a judge improperly denies one of your strikes for cause? I went to the Trial Lawyers College in 2009 or 2010. The person doing the appellate update section of that, I wish I could remember who it was. I can't, at this point, I can't even picture their face. But the one thing that I will never forget is he took the stage and he said, "Welcome to Texas appellate practice. All error is either harmless or waived." Now, the one piece of good news is that errors during voir dire and errors in jury charges are just about the only place anymore where you can get reversals for error in Texas. If a judge improperly leaves a juror who should have been stricken for cause, you can get a new trial on that basis if you preserve the error. So, what do you have to do to preserve the error? You have to show that you were ultimately left with an objectionable juror who wound up on your jury. Not one who should have been stricken for cause, but one that you didn't want, that you were forced to take because the judge improperly denied one of your strikes for cause. So, the steps to preserving error are, the first thing is you've got to make a timely motion to strike that juror. This is one where local practice may make a difference. There are some judges, I don't think there's anyone sitting at this point in Harris County, but there are a few visiting judges that have the rule that if they've said something you think subjects them to a strike for cause, you move then or not at all. If that's the deal, then that's one where it's especially helpful to ask for the juror's permission. Because then no one on the jury is confused about why you just turned around and said, "Judge, I have a motion." You've got to make the motion to strike. If that motion to strike is denied, you have to use a peremptory strike on the objectionable juror. If there are more than, so let's say he improperly denies 3 motions for cause, or motions to strike for cause. You've got 3 peremptories on a misdemeanor case. You have to use all 3 of those peremptories on jurors who should have been stricken for cause. Once you have, if there are more than the number of strikes you have, then I don't know what else you would do. I think you just have to use them all on jurors that you find objectionable. You have to use here's what it comes down to. Every juror that you find objectionable, that you have a peremptory strike to use, you have to use them on those jurors first. Then you have to make sure that you use up all of your peremptories. So let's kind of go through why the courts say each of these steps are necessary. Obviously, you have to make the motion to strike. If you don't tell the judge why you think the guy should be gone, the judge hasn't committed error by not kicking him off. You have to use a peremptory strike because the courts basically say, if this guy was that objectionable, you would have cut him. The fact that you use your peremptory strikes elsewhere means that that was harmless error. You may not have liked the guy, but you didn't like him bad enough to actually cut him when given the opportunity. You have to exhaust all your peremptory strikes. If you get to the end of the thing and you have peremptory strikes left over, then you weren't harmed because you didn't find the rest of the panel to be distasteful enough that you were harmed by this guy sticking around. I can think of maybe one case where we didn't exhaust all of our peremptories. So these first 3 are usually not a problem. Where people run into waiver errors and you have waived the issue if you don't do each of these steps, you have to ask the judge for additional peremptory strikes. So if there was one juror that you thought should have been stricken for cause, he denies it, you use your peremptory on that juror, use up the rest of your peremptories, and then you ask the judge, "Judge, I would like 1 additional peremptory strike." If he says yes, he's effectively given you the strike for cause that you've asked for. He's cured his error, and everybody can move along happily with the jury that they wanted. If he denies your request, or if he gives you an extra peremptory but also gives one to the state, he has not fixed the problem. And then finally, if he denies your request for additional peremptories, then you need to state on the record which juror made it onto your jury that if you had been given that additional peremptory, you would have struck that person and they wouldn't have been on the jury. Ultimately, what you have to do is you have to be able to point to a specific person on the record and say, Judge, this person is on this jury only because you improperly denied the strike for cause on juror number 8. The peremptory that I would have used on that guy, I had to waste on number 8. You wouldn't give me another one to cover this guy. I don't like this guy, and he wouldn't be on my jury but for your error. If you skip any of these steps, you can't get to that final analysis, and the appeals court will happily hold that you waived the issue. In my experience, judges are well aware of this scenario. I've had a few instances where the judge saw what I was doing and went ahead and gave me my additional peremptory. If you don't ask for that additional peremptory, every judge in that building knows that you've just waived that issue. It is not the judge's job to help you preserve error. No matter how friendly they are, no matter how unfriendly they may be, one thing is sure, it is not the judge's job to help you preserve your error. My experience has been, if a judge makes a ruling that they're questionable on, and you begin building a record, they'll seriously consider reversing themselves. If they make a call that they're questionable on, and it becomes clear to them that you're not making the record that you need to make to preserve this issue, they're going to move on. It is not only not their job, it is not in their interests to help you preserve error in your record. That's up to you. If like I said, by the time you reach the point that you're requesting additional peremptories, I've had a couple of judges go ahead and give me the additional peremptory. And basically what they're doing is they're going back and saying, okay, fine, you were right, I'm going to strike that guy for cause. And then you're using your peremptory the way you would have used them if they granted it in the first place, right? Let's see. Oh, here's the other one. Once you've been through that whole